Senator Rice.
Thank you, Madam Acting Deputy President. I'm rising today to speak about the Migration and Maritime Powers legislation resolving the Asylum Legacy Caseload Bill 2014. It's a very long name. It's a very complicated technical name. The thing that I want to focus on is this bill is about people. It's about real people. It's about people's lives. It's about people who are suffering. It's about people who Australians care about and Australians want to see protected. I think about the people, the refugees that this is going to affect, who I've met over the last 5 months whilst I've been a senator, and the many others that I've met prior to that. But in particular, I think about a lot of the refugees I met as I was on my journey to Canberra. I travelled to Canberra through regional Victoria on a listening tour, and along the way, at every stop, I managed to meet with members of the community, and the plight and the fate of refugees, both those that were living in the community, those that were languishing on Christmas Island, those that were locked up in detention on Nauru and Manus Island, were something that people were passionate about and they wanted to talk to me about. My first stop on my ride out of Melbourne was at Bacchus Marsh, and I met with some Burmese refugees who had been accepted as permanent residents. They were very fortunate compared to the more recent arrivals. They were working now as part of a social enterprise and were contributing to the country. They were growing vegetables. They were doing that with the support of the local church community and a local person who had donated land on the fertile river flats of the Werribee River at Bacchus Marsh to be helping this group of refugees, largely Burmese but also from other parts of the country. They were showing that Australians do have heart. They were contributing to part of the community and were really wanting and establishing their roots there. And I think the fact that they were growing vegetables on the bank of the river was showing that here they were establishing their roots, they had their kids going to local schools, and they were well on their way to becoming productive, happy Australians like the rest of us. With Australia as a culture, as a country, we have got people from all over the world, and our culture is based on the contributions from people all over the world, so many of them refugees. Our culture is based, as our national anthem says, our boundless plains to share, of accepting people and knowing that they can contribute to our diverse, multicultural country. This is the sort of approach, this is the sort of culture that is being so compromised and so attacked by this cruel and heartless legislation. From Bacchus Marsh, I moved on and was in Ballarat, and I was very fortunate to be in Ballarat at the launch of World Refugee Week, where I met with refugees from Sri Lanka and from Sierra Leone. I met with a young man from Africa who was now the Young Citizen of the Year in Ballarat. He had arrived from war-torn Africa, and he was here again, was now able to contribute to Australia. The Sri Lankan refugees, they were in a more difficult situation. I met with a number of them who were on bridging visas at that stage, and they wanted to talk to me about how we could help them, because all they wanted to do was to settle down and to help and to be part of an Australia and to be contributing to a vibrant, prosperous, healthy Australia and recognising the contributions that they were able to make. And they told me their stories, and that's the really sobering thing for me and for us here who all have got the opportunity to be living good lives, what these people have escaped from. The refugees that we are talking about are people who, through no fault of their own, are suffering. They have suffered torture, they have seen the death, they have seen the murder in many instances of friends, family, of people around them, and they have taken any opportunity, as you and I would, to flee for their lives. And I think putting ourselves in these people's shoes and say, if it's a choice of being shot or it's a choice of taking any opportunity to escape, taking any opportunity to save your children, to give your children the opportunity of a good life, you would take it. And that's the choice that people have been put in, and that's regardless of whatever way they can come to Australia, that they have tried to come here. I moved on my journey to Canberra from Ballarat and moved to Shepparton, where in Shepparton I met a group of approximately 60 Hazara men. I was working with the local Hazara community, and I'd said I was interested in meeting some of the local Hazara community living in regional areas, and offered to meet with them, and I expected that we would have around perhaps a dozen men and women that might like to meet with me. I arrived at the community hall that the meeting had been arranged in, and there were 60 of these Hazara men there wanting to talk to me, to tell me their stories and to see whether I could help them. Most of these men were on bridging visas. They didn't have the opportunity to work or study, and they didn't have the opportunity to bring their family out, who they knew was still in very dire circumstances in their home countries of Iraq, Iran, Afghanistan. All they wanted was the opportunity to contribute. All they wanted was the opportunity to be able to settle down and to work, to raise their families, and to know that they had the certainty of being able to be Australian residents permanently. They, like many other refugees before them, the expectation would be that if things calm down in Afghanistan, as we all hope that one day they may, that they would be able to move backwards and forwards, but still be able to come back to Australia and to see themselves as citizens, global citizens, moving backwards and forwards, as is the case in our modern society. But no, the circumstances they are in, and the circumstances they will continue to be in, even if they are offered one of these temporary protection visas, is not having that ability, not having the rights that they deserve, not having the rights that we should be able to offer people because of what they can contribute to Australia, and to be offering them safety and refuge. And then finally, the next group of refugees that I met was when I was in Albury-Wodonga. And there was some members of the African community there, but I also met with the Albury-Wodonga community group that was working with them, welcoming them to their community and supporting them as being part of the community. And meeting that group of people really gave me heart, because here, like all over Australia, you had people in rural Australia who were reaching out. They recognised the contributions that refugees from all over the world were able to make to their community, and they were welcoming them into their community. They wanted them to have the same rights, the same opportunities as other Australians. And that's what this cruel, very cruel bill is not going to give people, those opportunities. If passed, this bill is going to widen the Immigration Minister's powers. It's going to marginalise international law and the rules of natural justice, and it's going to severely restrict the ability of Australian courts to scrutinise the government's treatment of asylum seekers. The title of this bill, that I referred to at the beginning, the complex legalese, refers to the legacy caseload. And that's the 30,000 people, including the Hazara men I met in Shepparton, who have sought Australia's protection between August 2012 and December 2013, who have suffered the physical and mental anguish of mandatory detention, of family separation, absolute uncertainty about their legal status, and the constant risk of removal to Nauru and Manus Island. And again, referring to the people that I have met, the people that I have known who are in this circumstance, I can attest to that mental anguish, the depression that they feel because of just not having the certainty of knowing whether they're going to be able to stay, and not being able to sleep at night, not being able to know what their future holds. And the whole concept of only giving people temporary protection just feeds into that, when we as a country are better than that. We can be giving these people permanent protection. It's good for refugees, and it's good for us as Australians. To quote the New South Wales Bar Association, this bill goes far beyond what's necessary to deal with legacy caseload. It involves serious departures from Australia's international obligations, both to human rights and more generally. And to the extent that the bill does deal with the legacy caseload, it does so in a way which is procedurally unfair and unjust. And this is a piece of legislation that is the process for us considering this legislation today is just being so inappropriate given the severity of this legislation. And the significance of the changes proposed in this bill should not be understated. Along with the other bills before Parliament, this bill constitutes the single biggest change to Australia's asylum seeker policy ever made, and it is being rammed through here on this last day of sitting today, rammed through on the basis of a blackmail deal to say that you bring this bill, you support this bill, and that 500 children will be able to leave Christmas Island. This is not good process. It is not good lawmaking. It's not the sort of process that when I joined the Senate that I thought I would be part of. The bill's 6 schedules will fundamentally change the way that protection claims are assessed. It changes the criteria by which a person is found to be owed protection and the nature of that protection provided by Australia to those in genuine need. It also changes the legal status of those seeking our protection and empowers a range of government agencies to restrict or remove their liberty. And in each schedule, the bill removes the rare existing features of the Migration Act which operate to protect the rights and interests of asylum seekers. They haven't got many rights, but it's removing the rights that they've got in favour of a system that departs from international law and the rule of law principles. That's one of the very sad things about this, that in terms of Australia's contribution as being a global citizen, really living up to international law, we are departing from that and sending ourselves down a very, very sorry slope. Australia is better than that, and most Australians consider that that's not the direction for Australia that they want to see us taking. This bill is going to have a really ruthless impact on the lives, health and well-being of the 30,000 men, women and children that it's going to be subject to. We have already talked, other Green speakers, including Senator Hanson-Young, have talked of the brutal changes being proposed in Schedule 6, which are going to chillingly classify children born in Australia to asylum seeker parents by the deliberately depersonalising an Orwellian term of unauthorised maritime arrivals, and leave these babies stateless, leave these children stateless. These are children like yours, like mine. These children, they're beginnings of their lives. They're going to have such handicaps to overcome when we could be offering these children, these babies, a good life here in Australia. They could be kids like the kids that my children went to school with from all over the world, that we know that we're offering them security, support and the ability to contribute to the Australian society. And then, once these stateless babies, these unauthorised maritime arrivals, have been declared that way, they're then required to be detained and transferred to Nauru. We've seen what's the circumstances in Nauru. We've seen the cruel treatment of asylum seekers on Nauru. And we'll continue, this government's going to continue to hold children in those cruel, heartless circumstances that we know are going to have long-term impacts and long-term implications on the mental health of the children and the adults who are living there. This bill also astoundingly removes references to the Refugees Convention from the Migration Act and replaces them with the government's own interpretation of the convention. So these changes, which are purporting to allow they're allowing Australia to turn its back on the document that 145 nations have signed up to as a legal framework for the international protection of refugees. These measures have been condemned by the United Nations High Commission for Refugees and the Parliamentary Joint Committee on Human Rights as contrary to international law. They allow the minister to decide the definition of what is a refugee, and there is no review of that that's going to be allowed. This is not good law. And this go-it-alone approach has implications for any attempt Australia might make in future to engage the countries of our region in cooperating to address issues around processing and resettling asylum seekers. How can we possibly persuade other countries to fulfil their international obligations when our own actions show that we are prepared to manipulate and undermine an important international convention? Our hypocrisy will be seen for what it is. As I've already discussed, the bill is going to be introducing temporary protection visas and the safe haven enterprise visas. These visas only last for 3 or 4 years. They limit family reunion, and they require people who are found to be genuine refugees, people who have arrived genuinely seeking protection because of persecution. They are having to continually establish their internationally recognised right to protection just because of the way they entered Australia. As Save the Children has explained, TPVs will mean people fleeing persecution are left in limbo, forced to prove and reprove that they are refugees. The emotional and mental cost of such uncertainty is enormous and well documented. And again, it doesn't have to be this way. It is a choice of this parliament, if it ends up this bill being supported, to make it that way. The reintroduction of these visas is being pursued in the face of a significant body of medical evidence which shows the detrimental effects that TPVs have on people's mental health, and in blatant disregard of the actual facts. They are a hateful, punitive thing. The policy settings that existed the last time that TPVs were introduced have fundamentally changed. None of the deterrence-based arguments apply anymore. We do not need temporary protection visas. And this is because TPVs cannot possibly be seen as a deterrent to the 30,000 asylum seekers already in Australia, whose only other options are to return to a place of harm or face indefinite detention. And nor can TPVs be considered a deterrent to any future asylum seekers arriving by boat, because if they are intercepted, they must be removed to Nauru or Manus Island and will never be offered a TPV. This bill also removes fundamental procedural rights to safeguard the integrity of what can be a life or death decision about a person's need for protection. It does this by introducing a new fast-track procedure and by establishing the Immigration Assessment Authority to deal with the claims of asylum seekers who have arrived by sea in Australia without visas on or after the 13th of August 2012. And this fast-track process only gives asylum seekers one go at setting out the evidence needed to substantiate their protection claim to an immigration official, and it doesn't provide them with any access to independent advice or support. It flies in the face as what is recognised as good procedural and good legal practice. And so, for example, a woman who is fleeing politically motivated sexual violence, for example, will be required to assemble evidence to substantiate her claim without any expert help or support, and she'll only have limited time to do this. We are better than this. This isn't the rule of law that we should be having in an advanced, caring country like Australia. And to make things worse, under the fast-track process, applicants for protection visas will no longer be entitled to have the merits of their claim reviewed by the Refugee Review Tribunal. And in some cases, but not all, they may be able to have a negative decision fast-tracked by the Immigration Assessment Authority, but that review won't involve a hearing where the applicant can set out his or her claim for protection. And the decision will have to be made purely on the papers. They won't be interviewed or have the opportunity to comment on an application, and the applicant will not be allowed to provide new information or evidence except where exceptional circumstances exist. This is extraordinarily bad and it's undermining the whole nature of what it means to be a caring country and a caring Australia, and an Australia that has international obligations, an Australia that really says that we, consistent with the obligations that when we signed up to the Refugee Convention all those years ago, that we said that we were going to comply with. It's not the Australia that I want to live in, and I know it's not the Australia that thousands and thousands of people who have spoken to us want to live in. It's something that really needs to be rejected.